Hello, everyone. Thank you to all of the attendees who have joined us today for this discussion. My name is Milena Sterio, and I'm the Managing Director at the Public International Law and Policy Group and a Chaired Professor of Law at Cleveland State University. I will be moderating today's discussion, and I'm honored to be guiding the conversation with these experts. The Public International Law and Policy Group is a global pro bono law firm providing free legal assistance to parties involved in peace negotiations, post-conflict constitutions, and atrocity crime prosecution. This is the 30th Roundtable in PILPG's Thought Leadership Initiative. This initiative aims to share expertise and reflections from our work by organizing periodic roundtables that focus on prominent international law issues and pressing global conflicts. The legal status of nuclear weapons under international law, including public international law and international humanitarian law, is highly controversial. While the International Court of Justice attempted to provide some clarity on the question in its advisory opinion in 1996, the question ultimately remains unanswered. The Treaty on the Prohibition of Nuclear Weapons attempted to further regulate and prohibit the development, testing, production, use, and threat of using nuclear weapons. Nonetheless, as exemplified by the Russian threats of the use of nuclear weapons against Ukraine, the issue remains at the top of the agenda for many international lawyers. For today's expert roundtable, we will be discussing the status of nuclear weapons under international law, the legality of their production and use, and how their use would be prosecuted under international criminal law should it be necessary. Today's roundtable will be 60 minutes long. Our distinguished panelists include Mr. Grigory Plachkov, Professor David Koplow, and Jay Jackson. We ask that you please submit your questions that you have for our speakers using the Q&A function, and we will do our best to answer your questions either during the event or at the end of the event. Now, allow me just a few minutes to introduce our distinguished panelists. We're excited to welcome Mr. Grigory Plachkov, the former head of the State Nuclear Regulatory Inspectorate from 2017 until 2021. Since 2016, he's serving as the head of the Department of the Nuclear Industrial Complex, director of the Department of Nuclear Energy, and the Nuclear Industrial Complex of the Ministry of Energy and Coal Industry of Ukraine. Previously, he has worked as the head of the Department of Strategic Policy and Prospective Development of the Fuel and Energy Complex of the Ministry of Fuel and Energy of Ukraine and Deputy Director of Investments and Prospective Development of SE National Atomic Energy Generating Company, Energy Atom. Also joining us today is Professor David Koplow, Scott K. Ginsburg Professor of Law at Georgetown Law, where he teaches international law, arms control, non-proliferation, and terrorism. He has worked as special counsel for arms control to the General Counsel and Deputy General Counsel for International Affairs at the Department of Defense, and as attorney advisor and special assistant to the director of the U.S. Arms Control and Disarmament Agency. We are also honored to welcome Lieutenant Colonel Jay Jackson, a member of the United States Air Force Reserve, currently assigned to United States Strategic Command. In that role, he's responsible for providing legal advice to the commander and joint staff on all aspects of the command's global strategic mission, planning, and training. Lieutenant Colonel Jackson has served in the United States Air Force for 16 years and deployed 6 times to various conflict zones. He receives his Juris Doctor from George Mason University School of Law and a Master of Laws with highest honors in international and comparative law from the George Washington University Law School. Welcome, everyone, and thank you for agreeing to participate in today's panel. I would like to direct my first question to Grigory. Grigory, could you speak to the controversies surrounding nuclear weapons? Why is this such a contested field?
Дуже дякую за можливість.
Thank you so much. Thank you for this opportunity to take part in this event, in this roundtable. First of all, I would like to express our gratitude to all the American people for all the assistance and aid that you have been providing to Ukraine in this dire situation when we have a war with such a difficult aggressor as the Russian Federation. If we look historically, if we look into international law, Ukraine, as you know, after the Soviet Union collapsed, has received the third global nuclear potential. So the US had the first, second best was in the
Але Україна
Russian Federation, and historically, well, third largest was in Ukraine. But Ukraine, understanding that Ukraine is a civilized state, voluntarily just gave up this nuclear potential. And Ukraine in 1994 joined the Non-Proliferation Treaty, which was formed back in 1968. Also, Ukraine, Russia, the United States of America, and the United Kingdom have signed the memorandum on the assurances of security due to Ukraine joining the Non-Proliferation Treaty, the so-called Budapest Memorandum. In 1998, Ukraine and the IAEA have also concluded an agreement on the application of assurances under NPT. It was concluded in 1998. So these were the main foundational documents in Ukraine with regards to nuclear arms. Talking about nuclear substances and the safe use of nuclear energy, our state also has quite a lot of legislation and regulations. In 1997, Ukraine has ratified and joined the IAEA Convention on Nuclear Safety. In the year 2000, Ukraine has joined and ratified the Convention on radioactive waste and spent nuclear fuel. In 2005, Ukraine has joined the Convention on Physical Protection of Nuclear Material and Nuclear Facilities. So for us, for the specialists in nuclear energy, these are the main pillars and the main legislative and the main regulatory statutes which we use regularly. But Russia also is a party in the IAEA convention, yet you see that this whole framework and this whole international law structure unfortunately did not stop Russia in the current aggression when they were waging military activities in the direct vicinity of nuclear facilities and right on site, for example, Zaporizhia nuclear power plant and Chernobyl nuclear power plant. So
рівня там легальної бази, то це такі ось основні закони і міжнародні договори, якими ми керуємося в житті.
Thank you. Now, Grigory has already begun to outline the international law regulatory regime surrounding nuclear weapons. Let me go to Jay next. And Jay, are there gaps in this area? Where do these regulations limiting countries' abilities to use nuclear weapons come from? And are there gaps in those regulations?
Yeah, thank you, Milena. And as you said, Grigory did an excellent job sort of beginning to summarize just a few of the treaties that touch on this area. I think just to add a little bit to his introduction to the nuclear non-proliferation treaty as well, it does a few things. Before talking about the substance of that, I think it's important to first describe its framework, and specifically that the NPT divides the world into nuclear weapon states, that is, states that manufactured and exploded a device prior to January 1, 1967, and non-nuclear weapon states. And by the way, right, there are 5 nuclear weapon states: the United States, the United Kingdom, France, China, and Russia. And within that framework, first, the NPT prohibits nuclear weapon states from sharing with or transferring weapons technology to non-nuclear weapon states. And second, the NPT prohibits non-nuclear weapon states from acquiring nuclear weapons while generally guaranteeing their access to peaceful nuclear technology. Importantly, the NPT commits states parties to an eventual general and complete nuclear disarmament. 191 states parties to the NPT. So certainly I think Grigori was right to start there. Notable non-members of the NPT include India, Pakistan, Israel, and North Korea. The other area of law I think worth briefly summarizing before we jump into the gaps is that entire body of law known as international humanitarian law or the law of armed conflict. Through both treaties and established customary international law. International humanitarian law contains a number of specific rules containing to the application of force, protected people and objects, detention of civilians, shipwrecked personnel, prisoners of war, and so on. But it also contains some universal principles applicable to any armed conflict, including conflicts which might entail the use of nuclear weapons. Under the principle of distinction, for example, combatants may only attack enemy combatants and other military objectives. Under the principle of necessity, attacks are permitted only against targets that offer a definite military advantage, not just a hypothetical or speculative advantage. Under the principle of proportionality, military forces have an obligation to refrain from attacks, again, nuclear or otherwise, in which the expected harm incidental to those attacks would be excessive in relation to the concrete and direct military advantage to be gained. And we'll have, I think, the opportunity to discuss each of those principles in more detail later on and apply them to the use of nuclear weapons. But as to the question about gaps in the law, I'd be interested to hear what Grigori and David think about this. I actually believe there are relatively few legal gaps where there might be questions of policy or will, but in spite of their unique psychological and political significance and the important policy implications related to nuclear weapons, they for the most part represent a difference in scale rather than quality. Again, and stressing that's not to say there aren't unique aspects to warfare involving nuclear weapons, but unlike say the international law related to space or cyberspace, where even the domains can be difficult to describe, here our focus is on the application of international law to highly destructive weapons, but ones that have been around for nearly 80 years. And I think I would just add to those two bodies of law that there are a number of other treaties that impact the use and production of nuclear weapons. The Outer Space Treaty, for example, prohibits placement of nuclear weapons in Earth orbit. There are regional treaties creating nuclear weapon-free zones. Since the Cold War, there have been bilateral treaties, first between the United States and the Soviet Union, later Russia, limiting the number of deployed nuclear weapons. And most recently, there's the Treaty on the Prohibition of Nuclear Weapons, a treaty of 68 states committed to a complete ban on the development, the testing, the possession, and the use of nuclear weapons.
Thank you so much, Jay, which your last remark there was a great segue into my next question, which is for David, and which has to do precisely with that treaty. So in January of 2021, the Treaty on the Prohibition of Nuclear Weapons entered into force. So David, what does this mean for states that produce, test, store nuclear weapons, such as, for example, the United States, Russia, China, the UK, or France? The sort of, declared nuclear states.
Thank you, and thank you for organizing this very interesting and important panel on a very complicated area of law. And I guess in addressing the TPNW, the Treaty for the Prohibition of Nuclear Weapons, my answer starts in the same way all these conversations need to start with, on the one hand this, on the other hand that, or you could look at it this way, or you could look at it that way. On the TPNW, one way to address the impact that treaty will have on the countries that currently possess nuclear weapons, one way to address that is to say there'll be no impact at all. That this treaty, like all other treaties, has legal implications only for countries that have voluntarily decided to join the treaty, countries that have signed and ratified. And although there are 68 countries that have joined this treaty, which is a substantial number and noteworthy under international law, this is a very rapid pace of development for an international agreement. Ordinarily, you don't get to 68 as quickly as this treaty has. So the supporters, the proponents of the treaty are to be commended for that. But on the other hand, the 68 do not include any of the countries that currently possess nuclear weapons. They have all stayed away and declared their resistance to this treaty, and a treaty has no legal implications for countries that have not joined it. So the starting point is to say, this treaty, like any other treaty, has legal obligations only for its parties. Those parties do not include the 5 countries recognized as nuclear weapon states under the NPT, and do not include the 4 additional countries that have not joined. The second answer, however, is to say that this treaty, like much of international law, may have important implications even for countries that stay away. And one expression, one manifestation of that is to see the TPNW as a profound, deeply held expression by many countries around the world of dissatisfaction with the current structure and status of nuclear weapons in the world today. That is, the NPT, the foundational document in this field, as Jay emphasized, separates the world into countries that possess nuclear weapons and the countries that don't possess nuclear weapons, and the nons have an obligation never to possess them. The countries that do possess nuclear weapons have undertaken in Article 6 to commit themselves to good faith negotiations toward nuclear disarmament. And pursuant to that, there have been a series of international agreements that reduce the quantity and the character and the deployment of nuclear weapons around the world. But many countries would say that the countries that possess nuclear weapons have not gone nearly as far as they should in carrying out this obligation under Article 6 of the NPT. And one way to see the TPNW is that it's an assertion by many countries of dissatisfaction with the fundamental bargain of the NPT, to the extent that the TPNW puts additional pressure on the countries that possess nuclear weapons, to the extent that it leans in to the continuing global debate about the presence of nuclear weapons. The treaty may have an impact even on the countries that don't join it.
No, thank you for that answer, David. Now, could you, let me follow up with you on the following point. As you very, correctly stated, the new treaty, the Treaty on the Prohibition of Nuclear Weapons, does not bind states that are not members of that treaty. However, could you argue that there is a customary law norm which would be binding on all states, whether they're members of this treaty or not to ever use nuclear weapons?
Good. So Jay got us started down this path about the transcendent aspects of international law, that there are many important principles that are binding per se on every country around the world, whether those countries have joined the relevant treaties or not. And some countries have joined some of those treaties, others have stayed away from some of them. And the foundational points that Jay identified about distinction and proportionality and avoidance of unnecessary suffering, those all constitute customary international law. And in this instance, the International Court of Justice has reached the conclusion in an important advisory opinion that you noted in 1996, and said that nuclear weapons are fundamentally weapons. They get dealt with just like every other kind of weapon, and all the principles that apply to everything else apply just the same way to nuclear weapons. And so then the question is whether it is possible to imagine a use of nuclear weapons that would be in conformity with the rules about distinction and proportionality and all the rest of it. And there, the International Court of Justice's advisory opinion is both tremendously important and tremendously unclear. They say emphatically that it's hard to understand. It's scarcely reconcilable with international law to imagine a use of nuclear weapons, that in general, nuclear weapons could not satisfy the principles of discrimination and proportionality. But the court said, based on the information before us at the time, the court could not declare that there were no uses of nuclear weapons that could comply with international law. And that is the status of the international law on point today. there's a strong argument deeply held by many people, many countries, many judges on the ICJ that nuclear weapons are per se so powerful, their effects are so long lasting that there could be no uses that would be legal under the law of armed conflict. And just about an equally sized group of countries and judges and people around the world that say you might be able to imagine some circumstances where the use of nuclear weapons could nonetheless be legal. And that ambiguity is where we are right now.
Yes, and let me just add for our audience members, I was once in an international law trivia competition where the question was, name the ICJ case or advisory opinion where all 15 judges issued separate opinions. And the answer is the 1996 advisory opinion regarding the legality of the use of nuclear weapons. So I think it's fair to say that, David, you have very accurately summarized where we are today, but I think it's fair to say that there wasn't a ton of agreement among the ICJ judges regarding how do we address this issue of what are the types of circumstances where a state might be able to use nuclear weapons in a way which still comports with the relevant principles of international humanitarian law. And so
in fact, on the key vote on the exact point of the legality, the judges were tied 7-7, and it was, and the court's procedure is that the president of the court can cast a second vote to break the tie, and that's what was necessary in this instance. The opinions were that closely divided.
Exactly. I'll add that to the trivia competition for next year, David. Thank you. So with that, let me go to Jay and actually follow up on this. So, I think it's fair to say that everybody in the international community is mindful of the devastating and lingering effects of the use of atomic nuclear weapons from World War II and the widespread and long-term destruction and impact caused by the nuclear meltdown at Chernobyl in the 1980s. And now there's talk of dirty bombs and limited tactical nuclear weapons, which try to minimize some of those long-term effects. Looking more specifically at the relevant international humanitarian law principles, such as proportionality, distinction, the obligation on warring parties to avoid unnecessary suffering. In practice, is it possible for the use of nuclear weapons in an armed conflict to be proportionate to meet the requirements of distinction and the prevention of unnecessary suffering? Jay, can you come up with a hypothetical for us?
Yeah, thank you, Milena. And I think, it's funny, David, I think rightly noted that there are two camps. I know I'm probably, although my opinions today are my own and not those of the United States or Department of Defense. I think, my attire indicates which camp I might be in. And so, I believe that nuclear weapons could be used in a way consistent with the law of war. And in fact, U.S. policy states that if deterrence should ever fail, United States initiation and or conduct of nuclear operations would absolutely adhere to the law of armed conflict. If it's okay and helpful to listeners, I'd be happy to sort of walk through the principles that are that we're talking about here, and then we can talk, I think, about some good examples.
Please go ahead.
Okay, thank you. So first, you mentioned distinction, right? So combatants, as I mentioned earlier, can only attack other enemy combatants and military objectives. The civilian population, other protected persons and objects are not subject to attack. The principle of distinction involves a two-part test. First, to constitute a military objective, the object must by its nature, location, purpose, or use make an effective contribution to military action. And part of the reason I want to go through these things is I think it helps us understand the view of all of the targets that could be lawful military objectives under the law of war. And so in past conflicts, military objectives have included leadership facilities, communications objects, transportations objects, places of military significance, economic objects that are associated with military operations or are war supporting or war sustaining industries. And those include things like, again, electric power stations and objects associated with petroleum, oil, and lubricant production, but only when those objects make an effective contribution to the military action. In the second test, the second part of that distinction test is that a lawful target must be one whose total or partial destruction in the circumstances ruling at the time offers a definite military advantage. And again, that word definite means concrete and perceptible. So targets whose destruction is intended solely to impact civilian morale or the adversary's economy, for example. Those would not result in a definite military advantage because any resulting military effect wouldn't be concrete and perceptible. The second principle you mentioned, Milena, is unnecessary suffering. That is a prohibition of attacks which inflict suffering, injury, or destruction unnecessary to accomplish a legitimate military purpose. It's interesting, prior to the 1996 advisory opinion, some states argued that any use of nuclear weapons would violate that principle, that nuclear weapons just sort of by their nature involve superfluous injury and unnecessary suffering. The US, again, prior to that, noted that the prohibition against unnecessary injury and suffering is applicable only to suffering beyond that which is necessary to accomplish the military objective. In other words, it doesn't prohibit weapons that cause injury or suffering if the use of the weapon is necessary to accomplish a military mission. And so, perhaps a good example of that is anti-tank munitions that have to penetrate armor. They do so with increased kinetic effects or increased incendiary effects. They're not unlawful, even though they may also cause severe, painful burns to the tank crew. And that's because the injuries to the tank crew, they're not the point, they're incidental to an otherwise legitimate military purpose. And again, as David noted, the court couldn't conclude that there was a universal prohibition on the threat or use of nuclear weapons based on that principle. So turning back to the principle of proportionality, so that is the obligation for military forces to refrain from attacks in which the expected harm incidental to those attacks would be excessive in relation to the concrete and direct military advantage to be gained. I think probably that's where the bulk of this conversation can sit. If we assume that nuclear weapons would be directed towards a legitimate military objective, the question then really rests with proportionality. And paired with the principle of proportionality is a requirement that military forces take feasible precautions in planning and conducting attacks to reduce the harm to civilians and other protected persons and objects. The standard, by the way, that we use is due regard or diligence. There's not an absolute requirement to avoid incidental civilian harm. Judgments of proportionality are made in good faith and are based on the information available to the decision maker at the time. What is clearly prohibited is a wanton disregard for civilian casualties or harm to protected persons or objects. The example I would use, finally, Milena, getting to the question that you asked about, potential hypothetical. Two professors, Scott Sagan and Alan Weiner, wrote a paper last year in which they described a couple of examples of feasible precautions in nuclear operations, sort of two revolutions, an accuracy revolution in missile guidance technology and a low yield revolution in nuclear weapons technology. And so they take in the first instance the Polaris missile. So this is the sort of 1960s era missile deployed on US submarines. It had a circle error probable of 5,900 feet. So in other words, the chances of that 600 kiloton weapon landing within a mile of its target were about 50-50. In contrast, today, the United States deploys a B-61 nuclear bomb with an adjustable yield that reportedly can be reduced to just 2% of the yield of the atomic bomb dropped on Hiroshima. And that weapon has a circle error probable of less than 100 feet. And so without confirming or denying the specific facts and capabilities that Sagan and Weiner talk about in their article, the general idea of increased accuracy and ability to adjust yield, I think reflect how a nation could employ nuclear weapons against a military objective consistent with the principles that you said earlier.
Thank you. And I realize I put you in a difficult situation because nobody really wants to come forward with a blueprint of this is how you could use nuclear weapons, right? So, but thank you for walking us through those principles. That's very, very helpful. Let me turn to Grigori next. Turning to the situation in Ukraine, which unfortunately has been at the heart of this renewed interest in the legality or illegality of nuclear weapons. Some of President Putin's remarks regarding his plans for the war in Ukraine have raised widespread concerns about the potential use of nuclear weapons against Ukraine. Grigori, what is the current situation, and are there concerns within Ukraine about a potential nuclear war? Grigory, you're still on mute. If you can unmute yourself.
Дуже дякую за запитання.
Thank you for this question. So we are a strong nation. So we don't have any fear that Ukraine will be under nuclear bombardment. I don't see this fear among the populations. We are ready to any option that the Russian Federation can use against our population. But if we get back to this wider discussion and the international law, I think in the international law, they do not have a detailed definition of the nuclear terrorism. So it's difficult for me to say if the aggressor country captures a nuclear facility, the site of the nuclear power plant, and then uses this facility as the military base to blackmail the whole world, essentially, and they put the world at the verge of nuclear catastrophe. How do we treat this? How do we qualify this? Isn't it nuclear terrorism as part of the aggression? So it seems to me that the definition of the nuclear terrorism needs clarification in public international law, because the world has not yet met, has not yet encountered these things in the history of humanity. We've never had a situation when one country, which is a party of all the international treaties, would capture nuclear facilities of another country, which also is a party in these nuclear treaties. We've never had this precedent. With regards to nuclear arms, it's possible to incur a lot of damage to humanity and the environment, even without the nuclear arms. We have at least 3 examples of non-military use of nuclear facilities for harm. This is the 3 Mile Island, this is Chernobyl, and this is the Fukushima disaster. So the harm which both the countries and even the neighboring countries incurred, the harm from the civilian usage of nuclear energy can be tremendous. We've seen that. Ukraine, as a country, understands what nuclear energy is very well. We understand what nuclear material, nuclear substances are. We understand what IAEA guarantees are. So we are ready to any scenario which can happen and which the Russian Federation can use to blackmail and to cause this global fake news against Ukraine. So we are ready for anything.
Дякую.
Thank you so much. Now, we actually received an excellent question from one of our audience members. So let me go to this question and let me see which one of the panelists might want to answer this one. So the question goes as follows. The simple reality is that the international community could never hope to deal with the impact of nuclear weapons use, but the threat of mutually assured nuclear destruction deters countries from engaging in total interstate wars and gives countries incentive to strengthen international institutions through arms control treaties and collective security measures. How can the possibility and threat of use of nuclear weapons after the invasion of Ukraine by Russia, how can that possibility affect the negotiations with the countries who are developing nuclear programs, such as, for example, Iran or North Korea, and those who have them, to manage overall current efforts to limit these developments? In other words, the entire nuclear non-proliferation, program, and in a sense, the international community's ability to limit the proliferation and use of nuclear weapons depends to some extent on this mutually assured destruction strategy, and essentially countries realizing that, if we use nuclear weapons, someone else might use them against us. in the current context in Ukraine, unfortunately, there are these threats by Russia that they would use nuclear weapons, not against a nuclear state, but against a non-nuclear state. So how does this affect the entire regime of nuclear non-proliferation? I know that's a lot, but I do think that it's an important issue and a difficult issue to address at the moment. So this is a question for all three panelists, if anybody wants to try to tackle this one.
Якщо дозволите.
If I may,
Yes, please.
Я вважаю, що
I think
агресія Російської Федерації
that the aggression of the Russian Federation, well, not even the aggression, I mean, it's a full-scale war they are waging against Ukraine. And unfortunately, I agree with the author of the question. The whole architecture of the guarantees and the non-proliferation treaties, and not only for the for nuclear arms, but also for nuclear material, the framework has been destroyed. The system essentially works because IAEA had been doing inspections, not only in Ukraine, in other countries too, in all the parties to the non-proliferation treaty. However, unfortunately, with the activities of Russia, this architecture has been destroyed. I think the international community and the civilized countries after Ukrainian victory, well, we have to revise lots of international treaties, and we have to strengthen the liability for aggression against other countries, because unfortunately, once again, the system is there, but unfortunately the whole architecture of nuclear security, not only with regards to the non-proliferation of nuclear weapons, but also with regards to the peaceful use of nuclear energy on the whole, this architecture has been destroyed. Thank you.
Thank you. Jay, I see that you have unmuted. Would you like to add something to this?
Yeah, I was having a mute standoff with David. I'll be brief in case he's got anything to add. I really just wanted to add the point. I think the implication of the question really is a sobering one to think about. The only thing that I think I would add is that it's not only the possibility and use of nuclear aggression that I think runs counter to the goals of non-proliferation, but the possibility, threat, and use of any kind of aggression and armed conflict, I think causes countries to look for an asymmetrical advantage to defend themselves. And so I guess I would just broaden it to say that perhaps it's even scarier in the sense that it's not just the possibility and threat of nuclear warfare that causes states to look for that advantage, but conventional warfare as well.
And David?
Well, so let me make 2 points in the interest of generating some disagreement among our panel, which I think is always more interesting. The first is that Gregory claimed that the Russian invasion has destroyed the legal structure. And I disagree with the word destroyed. I think the Russian invasion is a serious blow. It is a terrible problem. It is illegal, immoral, and unwise. But I do not think it has destroyed the international structure. The world has seen other terrible aggression in the world, in the post-World War II era, and the structures are still there, and I hope will continue to limp along into the future, dealing in some way with this kind of terrible blow. It is certainly an indication of a weakness, a vulnerability, a shortcoming in the system, but I hope it's not destroyed because it's the only system we've got. The second point that I'd make, and again, maybe in the interest of generating disagreement, is that the fundamental problem here is the possession of nuclear weapons. That's what poses the threat to the world. Countries have invaded each other throughout human history and sometimes inflicted enormous suffering and massive deaths. But what we've got now is the possibility that warfare could end all human life on Earth. That's the unique characteristic of nuclear weapons, and that's what provides the enormous incentive to get rid of all nuclear weapons, not just to restrain their use, not just to make sure that they're used in only small ways that would comply with the law of armed conflict. This is a threat to all of humanity, and the only way to eradicate that threat is to eradicate nuclear weapons.
Thank you. Now, let me go to the following question, which I think we have already alluded to. But the question is for all the panelists, but I would love to hear from Grigori in particular. Recently, Russia has accused Ukraine of developing a dirty bomb. Nonetheless, when the International Atomic Energy Agency was invited to inspect nuclear sites in Ukraine, it found that there's no such undeclared activity. What may be Russia's intention when making these unfounded accusations? And is Ukraine in a position to develop a nuclear weapon in the near future should it decide to do so? Now, of course, we're not asking you to spill any state secrets here, simply to answer, as much as you can. Grigori, if you can unmute again.
Дякую за запитання. Ви почали...
Thank you for this question. So you've started with the dirty bomb and then and then you came to the development of nuclear weapons. These are different things. In Ukraine, so it happened historically that we had a lot of nuclear material in different forms. This is both fresh and spent nuclear fuel. We also have radioactive waste which accumulated during the operation of nuclear power plants. We have sources of ionizing radiation. So following the logic of the Russian Federation, you can accuse any country in the world which has 2 X-ray machines and 3 physicists and 1 multiple launch rocket system. So any nuclear material which is in Ukraine is secured and it is guaranteed by the state. And the main function of the IAEA is ensuring and controlling the non-proliferation of nuclear material. So all the sites where there's fuel or some nuclear material have the corresponding IAEA, all the cameras and devices, and the headquarters in Vienna. They can monitor all these sites. They can control whether Ukraine is ensuring safety and security, and they can do this monitoring 24/7. So I'm not surprised by the IAEA statements that, well, Ukraine doesn't have any intention to create this dirty bomb. But hypothetically, having nuclear material in large quantities, I mean, hypothetically, it could be possible, but it could be possible for any country, not only Ukraine. And secondly, the second objective that the Russian Federation is trying to achieve, in my opinion, is that they want to spread this disinformation, that Ukraine is trying to contaminate something. But would it even make sense to contaminate the territory if Ukraine is fighting to deoccupy this territory? Why would we want to contaminate our territory? It just makes no sense at all, as usual in the statements of the Russian Federation. Thank you.
Thank you. And let me, David or Jade, would you like to weigh in on this one, or should we move on to the next question?
Well, let me just say quickly, it's no surprise that Putin is lying about this as part of his war effort, as part of his effort to remain in power. He doesn't have any trouble telling lies about a lot of things. It is true, as Grigori was saying, that developing, building, using a dirty bomb is not that hard. It's much easier than developing a nuclear weapon, a nuclear explosive device. And that's something that a country could do, but there's no reason why Ukraine would do that. It just wouldn't make any sense tactically for Ukraine to do that now. And therefore, the worry is that this is Putin planting the seeds of a false flag operation, accusing others of doing something that he may himself wind up doing before very long and wants to blame somebody else for starting it.
Thank you. Now, my next question is for, Grigori, do you have your hand up? Go ahead. If you can unmute. Thank you.
Щодо ядерної
Now,
зброї,
as for the nuclear weapons, Ukraine cannot develop nuclear weapons because Ukraine has no so-called double technology. We have no capacity to enrich uranium in order to use nuclear weapons. We do need this kind of materials. We don't have this dual use technology to enrich uranium or plutonium. That's a very short answer as to the development of nuclear weapons by Ukraine.
Thank you so much. So let me go to you next, Jay. I think the one point that we can all agree on is that Russia has initiated an aggressive war against Ukraine, and that Ukraine, whatever force it uses against Russia, would be, has been using such force in self-defense. So when we talk about the use of nuclear weapons in self-defense, Jay, how would you apply the International Court of Justice advisory opinion framework to a defensive use of nuclear weapons? Or do you think that it makes no difference whether a country is using nuclear weapons in an aggressive way or in self-defense?
Yeah, thank you, Milena. I think that how David described what Putin is doing is exactly right. And in the extent that it's just a continuation of the nature of hybrid warfare, where attribution is difficult, misinformation is rampant, that the target of the aggression is population centric rather than military centric. And so to see this applied now into either, again, the possibility or threat of the use of nuclear weapons is certainly scary, and something, though, that I think complicates self-defense. I sort of never imagined that. I think, growing up as a kid in Florida in the Cold War, that attribution would be a difficult feature of a nuclear attack. You sort of always knew or assumed that you would know exactly where it was coming from, who was responsible, and why. And so while Article 51 of the UN Charter affirms that nations have an inherent right of individual and collective self-defense, maybe that's the first challenge that we need to discuss is how misinformation and misattribution might affect an attack. And again, following up, the opinion or the ICJ opinion expressly stated that talks about the inherent right of self-defense and said that it does not refer to specific weapons. And it noted only as a general matter that the UN Charter neither prohibited nor permitted the use of any specific weapon, including nuclear weapons. Now, in the context of a dirty bomb, of course, self-defense is not a reason to use an otherwise prohibited weapon. But I think that's where we are. And so what we do is we look back to the 1986 Nicaragua opinion by the court, where it established a rule that self-defense would warrant only those measures which were proportional to the armed attack and necessary to respond to it. Again, before the opinion, other states said no. The very nature of nuclear weapons and the probability of escalation of nuclear exchanges, the sort of global destruction that David described, said that there was an extremely strong risk of devastation, and the court declined to take such a strict approach. I think David said earlier, important opinion, but unhelpful in so many regards. I've got the conclusion of a piece of the opinion here. They said it suffices for the court to note that the very nature of all nuclear weapons and the profound risks associated therewith are further considerations to be borne in mind by states. So just things to be considered when considering proportionality by states believing that they can exercise a nuclear response in self-defense.
Thank you, Jay. Now, let me turn to another audience question. And oh, David, go ahead.
I was just going to elaborate just a bit on what Jay just said, because I think it's important for the audience to understand that what's often referred to as the law of war has two separate components. One about initiation of hostility, the circumstances under which it is lawful to go to war, and the other is about the conduct of hostilities. Once you are in an armed conflict, what tools and tactics are permitted and what are prohibited. And importantly, those are separate. Those are completely distinct inquiries. So whether the war whether your initiation of the fight, whether you are the aggressor or whether you're acting in self-defense, you are still bound by the entire corpus of the law about means and methods of warfare. So the fact that Ukraine is acting in self-defense here does not give it any additional permissions to use nuclear weapons beyond what the standing law of armed conflict would provide, which we've talked about earlier, necessity, proportionality, and all that. The adverse circumstances of the initiation does not affect the conduct of the fighting.
Absolutely right. Yeah, thank you, David.
Thank you for the clarification. Now, let me go to an audience question and actually tied to a question that I already had for David, but if others would like to weigh in, please go ahead. So the audience question basically asked about provisions under international law regarding impeachment of persons like President Putin who flagrantly violate provisions of international law by, for example, using nuclear weapons against Ukraine. So let me ask David, if Russia, nobody wants to envision this, but if Russia were to use nuclear weapons against Ukraine, would this constitute a war crime or a crime against humanity or genocide? And what types of accountability options might we have at our disposal to punish someone like Putin?
Good. So first of all, the concept of impeachment is just not the right category here. Impeachment is a mechanism under the domestic law of any particular country for removal of a senior elected official or other leader. And many countries have such a process, but it's a matter of your domestic legal structure, not something that other countries could impose upon you. But what other countries can do is enforce the international criminal law that applies to this kind of behavior. And Putin would be subject to that if he were apprehended and brought to some sort of international or foreign domestic tribunal. There are a couple of ways in which that might happen, and depending on the circumstances, this might be a prosecution for genocide or war crimes or crimes against humanity or all of that. The reason that you have to be a little bit vague at this point is that it hasn't happened yet, blessedly. And if it does happen, you'd need to know exactly what the circumstances are. And just one illustration of that, the crime of genocide is defined under a treaty. And genocide consists, as many criminal acts do, of two elements. One is a physical action and another is a state of mind. The physical action for genocide refers to the killing of a particular group of people. The state of mind requires an intention to destroy that group based on their national or cultural or religious identification. And therefore, the prosecutors, whoever they might be, would have to demonstrate that Putin was using a nuclear weapon for the particular purpose of destroying Ukraine and Ukrainians as an ethnic, religious, racial, national identity. That's not so easy to do because in defense, Putin might say, no, I wasn't trying to destroy them. This is part of a war fight. And in fact, I consider Ukrainians to be Russian. And therefore, I'm not trying to destroy them. I'm trying to integrate them into to Mother Russia. I think there's a response to each of those. But the point is that as with domestic criminal law in every country, international criminal law puts a burden on the prosecutor to prove each element of the claim, and some of them would require very minute factual interpretation.
Thank you, David. Now we're running out of time, so I wanted to ask one last question and invite each of our panelists to briefly answer. And that is, what do you think is the future in this area of the law? And really the elephant in the room, and I'm going to push Jay on this question, is, should nuclear weapons be outlawed more firmly by an international treaty, or should more states join this new treaty that we have in place? Because this situation in Ukraine clearly demonstrates the danger of the fact that some countries have nuclear weapons, and that the international law regulatory regime doesn't so clearly outlaw all uses of nuclear weapons. So what is the future here, and do you think that nuclear weapons actually should be banned? So let me start with Jay.
Yeah, thanks, Milena. I think like all of us, hope that this is a zero growth industry, that we can live up to the aspirations of the NPT and their goal of the cessation of manufacture and the elimination of arsenals. And we would all have to find a new field of study, and that would be a wonderful thing. But until that day, I don't think that an outlawing is a realistic goal. You mentioned the elephant in the room. I think the elephant in the room that we haven't discussed is China. And a more realistic goal in the near future might be the inclusion of China in a multilateral or unilateral nuclear arms treaty. 2 years ago, the U.S. Department of Defense estimated that they would double their nuclear arsenal by 2030. So from about 200 warheads to about 400 warheads. And now, it's estimated that they'll have over 1,000. So I think in terms of focus of a realistic sort of short to medium term goal, that would be the best area of focus.
David?
So from my perspective, the concept of the United States unilaterally getting rid of its nuclear weapons is just not on the table. That would be foolish, and that's not what we're talking about. What we are talking about is advancing an international effort to get all countries to dispose of their nuclear weapons. And it seems to me that that notion that sometimes in the past has been seen as idealistic or unrealistic, it's the only realistic path forward. It's the only way to maintain the prospects for our species survival. The elephant in the room for me, deterrence has played a role and gets some of the credit for maintaining, for avoiding World War III. But for me, the elephant in the room is that the continued possession of nuclear weapons is sort of like the circumstance of a guy who falls off the top of a 100-story building. And as he's plummeting past the 50th floor, he's heard to say, well, so far, so good. That's the circumstance that we're in with respect to nuclear weapons. To some extent, they have provided an important, enduring national security benefit in avoiding World War III, but it's not sustainable. We got to stop this.
Thank you. And Grigori, you have the last word.
Yeah, thank you. I support my colleagues for in the sense that the nuclear weapons can be used only as a deterrence tool. There is no other use, no other sensible use. It requires a lot of maintenance, a lot of cost and resources. I believe we have to use our resources for novelty projects aimed at peaceful use of nuclear materials, not for threats or other destructive use. Yeah, and I think it's the choice of every nation possessing nuclear weapons. Apart from China, there is another example, Israel. We are unclear 100% about their status. So we have to aspire for evidence-based strategic goals, so to say. That would be new. Thank you.
Thank you so much. Unfortunately, in spite of the significant importance of this discussion, this is all that we have time for today. Thank you for joining us and submitting your questions. The webinar recording will be available on the PILPG website and shared with all of the attendees on Zoom via email. This event was part of the PILPG Thought Leadership Development Series. Thank you very much to our panelists for taking the time today to talk about the status of nuclear weapons in international law. And I invite all of our attendees to follow our Thought Leadership Initiative and to join us for our next event. Thank you.
Дякую.